Welcome to the lecture for Assignment 6, Intentional Torts. Please make sure that you have your textbook in front of you and your question batch 6 questions before listening to this lecture. Now let's start first of all with a definition of for tort. A tort is a civil wrong causing injury to persons, their property, or their economic interests. And we're going to take a look at several different intentional torts, including battery, assault, false imprisonment, intentional infliction of emotional distress, trespass to real property, trespass to personal property, conversion, and defamation. Those are the 8 torts that will be discussed in this lecture. So first off, let's look at battery. Battery is a harmful or offensive contact with plaintiff's person. A harmful or offensive contact with plaintiff's person. And sometimes people will substitute the word unpermitted in there as well. So let me give you an example. Let's say, for example, somebody comes up to you and for no good reason intentionally punches you right in the face. Do we have a battery? Well, ask yourself, was there a harmful or offensive, or at least a bare minimum unpermitted contact with your person? If so, then we have a battery. Now keep in mind also that all the defendant needs to do is touch something connected with the plaintiff's person to satisfy the battery requirement. So if, for example, your enemy you see driving down the road in their vehicle while you are driving in your vehicle, if you intentionally ram their vehicle with your vehicle, a battery has been committed. Again, all defendant needs to do is touch something connected with the plaintiff's person to satisfy the battery requirement. If also you decide that you want to shoot your enemy with a gun, again for no good reason, we're going to have a battery committed. Right? That bullet, when it makes a connection, when it makes contact with the plaintiff's person, the battery requirement will have been satisfied. Now, I don't want you to get this unpermitted term. I don't want you to get carried away with it. Some of you at this point may be thinking, well, what would happen, for example, if I was walking down the hall and I was trying to find the restroom and somebody was walking in front of me with their back turned to me and I gave them a light tap on the shoulder and asked them where the restroom is? You know, have I committed a battery? Well, even though that light tap on the shoulder may have been unpermitted contact with the other person, the thing to keep in mind is that with intentional torts, plaintiff supersensitivities do not count unless the defendant knew of them. So you got to ask yourself, would the average person have permitted a very light tap on the shoulder by somebody asking where the restrooms are? I would think so. And in that scenario, a battery would not have been committed. Let's move on to assault. Assault is a reasonable apprehension of an immediate battery. A reasonable apprehension of an immediate battery. Right? You point a gun at somebody and you tell that person, I'm going to blow your head off. Right? Do we have an assault? Well, let's see. From the other party's perspective, do we have a reasonable apprehension of an immediate battery? Well, the battery would have been the bullet flying out of the gun and into the other party's chest. Now, the key thing to remember with reasonable apprehension is apparent ability creates a reasonable apprehension. Apparent ability creates a reasonable apprehension. You point a gun at somebody and say, I'm going to blow your head off. The other party sues you for an assault. In your defense, you say there was no bullet in the gun. We don't care. Right? And apparent ability will create a reasonable apprehension. Okay, reasonable apprehension of an immediate battery. That's an assault. Next, let's turn to false imprisonment. False imprisonment is a sufficient act of restraint to confine the plaintiff to a bounded area. A sufficient act of restraint to confine the plaintiff to a bounded area. So with the bounded area, essentially the freedom of movement must be hemmed in. So if, for example, in my face-to-face section of this Business Law 1 class, if I decided that I'm going to jam the door so nobody in the class can get out, my students would likely have a valid false imprisonment claim that they could bring against me. There's a sufficient act of restraint. That would be me wedging the door shut so nobody can open it to confine the individuals to a bounded area. That would be false imprisonment. You know, think about kidnapping. If you were kidnapped and you wanted to file a civil suit against the kidnapper, you may want to start thinking about false imprisonment. Again, there would be a sufficient act of restraint to confine the plaintiff to a bounded area. Next, let's take a look at the tort, the intentional tort of intentional infliction of emotional distress, sometimes referred to as intentional infliction of mental distress. In order for this tort to have occurred, we need to have outrageous conduct and damage. And for damage, you need to show substantial emotional distress. So let's look at the first part. You need outrageous conduct and damage. Notice that with outrageous, all the letters in the word are capitalized. The word is underlined. I mean, it really has to go somewhere. Let's suppose for a second that you have a fellow classmate who's been calling you a name and that bothers you a little bit, and you've been having a couple of sleepless nights, and you're thinking about suing the classmate for intentional infliction of emotional distress, case is probably not going to go anywhere. Again, to make out this intentional tort, you need to have outrageous conduct. A little bit of name calling, that's just something we all have to live with in this friction-filled world. Okay? You need outrageous conduct. And for damage, you need to show substantial emotional distress. Let me give you another example. Let's assume for a second that you're coming home from work and somebody tells you that your 3-year-old daughter has been run over by a truck and has recently just been killed. And then you suffer a heart attack based on the news. Well, here we would have outrageous conduct, and the damage, the heart attack, would be pretty substantial. So in this scenario, the elements for intentional infliction of emotional distress may have been made out. Let's take a look at the next tort. Trespass to real property or trespass to land. Definition of real property, incidentally, is land and anything permanently attached to land. So in some books, this tort may be referred to as trespass to land. I believe in your textbook, the tort is referred to as trespass to real property. But for this tort, the defendant must invade the plaintiff's land, and the defendant does not have to physically go on the plaintiff's land. However, some object must go on the property. So if, for example, you had a neighbor that you didn't much care for, and you decided to go on your neighbor's property without his permission and dig a bunch of holes in the land. Well, obviously that would be trespass to land, trespass to real property. But you could also trespass upon the real property of another without physically going on the land. For example, if you threw bombs onto your neighbor's property and the bombs exploded, causing damage to the land, we would also have trespass to land as well. Again, the defendant must invade the plaintiff's land, and the defendant does not have to physically go onto the plaintiff's land. However, some object must go on the property. Now, closely related to this tort of trespass to land is what is referred to as nuisance. If you take a look on page 126 in your textbook, The textbook will describe what a nuisance is. And this is on page 126 towards the bottom after the heading nuisance. It reads, a nuisance is a non-trespassory invasion of another's interest in the private use and enjoyment of the land. In contrast to trespass, nuisance does not require interference with another's right to exclusive possession of the land, but imposes liability for significant and unreasonable harm to another's use or enjoyment of the land. Examples of nuisance include the emission of unpleasant odors, smoke, dust, or gas, as well as the pollution of a stream, pond, or underground water supply. So for example, if you had a next door neighbor that you didn't like, and you really wanted to bother the next door neighbor, and you decided to dump a pile of manure on your property, but right next to the property line of your neighbor, and you knew that the unpleasant odors from the manure would go in through the screen of the kitchen window of your neighbor and would cause some unpleasantness. Well, we don't have a trespass to land action because you have not actually invaded the plaintiff's land, but you have certainly interfered with your neighbor's enjoyment of his property. So therefore, your neighbor might be thinking about bringing a nuisance action against you. Let's move on to the next intentional tort, which is trespass to chattels, or if you prefer, trespass to personal property. Now, I just mentioned that the definition of real property is land and anything permanently attached to land. Personal property would be any property that's not real property. Now, obviously, real property would be, well, it would be land. Real property would also be a house because it's permanently attached to land. An example of personal property could be an automobile. It's not permanently attached to land. It could be the textbook that you have in front of you. Again, it's property that's not permanently attached to land. So trespass to chattels, also referred to as trespass to personal property. For this tort, the plaintiff must prove that the defendant deprived him of possession of his property or damaged his property, and plaintiff can recover only for actual damage and perhaps use. Now I'm going to move on to the next tort, which is conversion, which also deals with a trespass to personal property. And then I'm going to come back to trespass to chattels to compare what the difference is between trespass to chattels and conversion. So let's move ahead, and then we're going to move back, and I'll provide a couple examples, and hopefully you'll be able to distinguish between trespass to chattels and conversion. So let's go to conversion. In conversion, the plaintiff has the opportunity to turn the property into a forced sale and recover the full price of the property taken. To establish conversion, the defendant must show an intention or purpose to exercise ownership over the goods or prevent the owner from taking possession of his property. Now, both torts, trespass to chattels and conversion, both deal with trespass to personal property of the defendant. However, with trespass to chattels, what you should be thinking about is there was a little bit of damage. With conversion, you should be thinking that, well, there was a lot of damage. So for example, if you decided to take your neighbor's automobile and you're going to play a practical joke on your neighbor, and you're going to drive the automobile 2 blocks, and you're going to park your neighbor's automobile 2 blocks away, and this is going to drive your neighbor crazy because it takes your neighbor 3 hours to find his automobile. And if your neighbor is thinking about bringing an intentional torts actions against you, then your neighbor would be thinking about trespass to chattels, because you would have deprived your neighbor of his possession of the property. And in terms of damages, there isn't a whole lot of damage. Plaintiff can recover for only actual damage and perhaps use. So in terms of a monetary value, actual damage, well, you know, if there was any minor damage to the vehicle, your neighbor could sue for that. And in terms of use, I mean, your neighbor was deprived of possession of the automobile for 3 hours. So, what would be the fair rental value of an automobile for 3 hours? There's not a whole lot of damage there. There's a deprivation of possession of the property, but there's not a whole lot of damage. So we're thinking trespass to chattels. However, if instead you decided to steal your neighbor's automobile and for kicks go on a joyride and push the vehicle off a cliff, destroying the vehicle, now we've got a lot of damage to personal property, and now your neighbor is probably thinking about bringing a conversion action. In a conversion action, the plaintiff has the opportunity to turn the property into a forced sale, meaning that the plaintiff can sue for the fair market value of the property taken. And to establish conversion, the defendant must show an intention or purpose to exercise ownership over the goods or prevent the owner from taking possession of his property. Again, both torts deal with a deprivation of possession of personal property. However, in trespass to chattels, there's a little bit of damage. Conversion, there's a lot of damage. Now, I'm just going to pause for a quick second and talk about intentional tort defenses. And there are a few intentional tort defenses. One would be consent. So, for example, if your buddy goes up to you and says, "Hey, I'm going to punch you as hard as I can in the stomach," and you say, "Go ahead," and then your buddy does punch you as hard as he can in the stomach, and you start thinking about bringing a battery action against your buddy, where your buddy's defense could be consent. Okay, you consented to the battery. That would be a defense to an intentional tort action. Other common defenses would be self-defense, defense of others, defense of property. All right, so you punch somebody in the face and they're bringing a battery action against you, and your defense is the only reason that you punched them is they were going to punch you when you were just defending yourself. Again, self-defense, defense of others, defense of property could also be a defense to an intentional tort action. Please take a look at question batch 6. At this point, we should be able to do the first 4 questions. The first question states, blank is the intentional infliction of an apprehension of an immediate bodily harm or offensive contact. Now the answer to this is going to be B, assault. I'd like you to notice on the PowerPoint slides the definitions that I've given you are slightly different than the definitions in the textbook. However, this is a good place to point out that when you're studying for the exam, and I will give you study tips for the first exam at least 1 week prior to the first exam, and one of the study tips will be review the definition for assault. Whenever I ask you to review a definition for the purpose of studying for the exam, in order to be consistent, I'd like you to know the definition as it's stated in the textbook. However, from time to time, I might give you a slightly different definition in a PowerPoint slide, just because maybe I like the way it's worded better. All right? But the answer to question 1 is B. It's assault. Assault is the intentional infliction of an apprehension of immediate bodily harm or offensive contact, and that's a definition of assault as stated in the textbook. Number 2, blank is the intentional interference with a person's freedom of movement by unlawful confinement. The answer to 2 is C, false imprisonment. Question 3, blank is the intentional infliction of harmful or offensive bodily contact. Answer A, battery. And question 4 says, Albert parks his car in front of his house. Later, Frank pushes Albert's car around the corner. Albert subsequently looks for his car but cannot find it for several hours. Frank is liable to Albert for. Answer is A, trespass to chattels, also referred to as trespass to personal property. Again, in this situation, there's a deprivation of the possession of personal property which caused a little bit of damage. I mean, if Albert would have driven the car off the cliff, we'd be thinking about a conversion action because there would be a lot of damage. But in this situation, a little bit of damage with a deprivation of property. Therefore, the best answer is A, trespass to chattels. Let's move on to our final intentional tort, which is defamation. Defamation is defined as injury to a plaintiff's reputation. With defamation, what we need is, number one, a defamatory statement about this plaintiff. Number two, a publication. And number three, injury to the plaintiff's reputation. So to make out a defamation action, okay, which involves injury to a plaintiff's reputation, you need to show a defamatory statement about the plaintiff, a publication, and injury to the plaintiff's reputation. Now, the statement must include a defamatory assertion of fact. Mere name-calling is not enough. So if, for example, one of you was to come up to me and say, Dr. Engdahl, you're a pretty poor professor, and you did so in the presence of others. Again, this is not a defamatory assertion of fact. This is your opinion. It's not going to rise to the level of a defamatory statement. If, however, in the presence of your classmates, you came up to me and said, Dr. Engdahl, you smoke crack? Well, assuming that I don't smoke crack, that would be a defamatory assertion of a fact. That would certainly be a statement that would be damaging to my reputation as a professor. Second element of defamation is a publication. A publication requires a communication to a third person. So if, for example, you came up to me in private and said, Dr. Engdahl, you smoke crack? Again, assuming that I don't smoke crack, right? We do not have a publication. There was no third person presence. However, if you made the statement in the presence of a third person, then the publication requirement would be satisfied. What else do we need? Well, certainly we need injury to a plaintiff's reputation. Now, there are a couple of different types of defamation. There's libel and there's slander. Libel consists of the written word. Slander consists of the spoken word. So if, for example, in the presence of others, you stated, Dr. Engdahl, you smoke crack, and you said it out loud, we've got slander. If, however, you sent out an email with that statement, again, to at least one third party, then it would be considered libel. It would be in writing. Let's take a look at defamation defenses. The first one is consent. All right, sticking with the, I guess, the crack example. If, for example, you came up to me and said, Dr. Engdahl, I'm going to tell the entire class that you smoke crack, and I say, go ahead, and then later I sue you for defamation, what's your defense? Consent. You told me you were going to make a defamatory statement about me. I said, go ahead. That would be your defense. Second one is truth. If you stand up and say, Dr. Engdahl, you smoke crack in front of the entire class, and if, for example, I did smoke crack and you had some evidence about it, defense is truth. Okay, it's no defamatory statement because, well, it's a true statement. Other defenses to defamation would be absolute privileges and conditional. In other words, qualified privileges. Let's take a look at absolute privileges first. These protect the defendant regardless of motive or intent, and these would include communications between spouses and the three governmental branches, including when you're on the witness stand. So what the law is saying is that we want to be able to encourage communication between spouses without having to worry about one spouse or the other making a defamatory statement. So if, for example, you went home at night and said to your spouse that, you know that Dr. Engdahl, he smokes crack. Now, assuming that's a defamatory statement, if I was to sue you for defamation, what's your defense? It's an absolute privilege. You should be able to say whatever you want about anybody else when you're communicating with your spouse in private. Okay, same thing in a witness stand. We want witnesses to be able to say what it is they think without having to worry about defamation liability. Now, with a qualified or conditional privilege, this is going to depend on the defendant's proper use of the privilege. This is a situation where if the defendant abuses the privilege, he loses the privilege. So an example would be of reference. Let's say, for example, I had a student come to me for a reference, and I gave a reference of the student that was far from glowing. Well, what the law wants to do is encourage people to give references of somebody else and to speak honestly and freely without having to worry about defamation liability. So even if I included something in that reference that could be defamatory, I could invoke my qualified or conditional privilege so long as I didn't abuse it. Now, that being said, a qualified privilege can be overcome if the statement was made with knowledge that it was false or with reckless disregard for the truth. So a qualified or conditional privilege, the defendant doesn't always have it. Again, if he abuses the privilege, he can lose the privilege. And the best example where a qualified privilege could be invoked is that when one gives a reference for somebody else. Let's turn now to invasion of privacy. The first thing that you need to know about invasion of privacy is that it's not a tort. Instead, it's a designation that encompasses 4 distinct branches. The first branch is going to be the appropriation by defendant of plaintiff's name or picture for defendant's commercial advantage. It's the appropriation by defendant of plaintiff's name or picture for defendant's commercial advantage. And this is limited to the promotion of a service or product. So let's say, for example, that you're starting a company and your company makes a sport drink that's trying to compete with Gatorade and Powerade. And what would be better to market this sport drink than if you can align yourself with a famous athlete like LeBron James? So you come up with a name for the company and the drink called Sportaid, for example, and you embark on an advertising campaign. And in Sports Illustrated and all the other major sport publications, there's a picture that says "Drink Sportaid," and right beneath the slogan "Drink Sportaid," there's a picture of LeBron James dunking. Now you think this is pretty smart because you think that if people see LeBron James dunking a basketball underneath the slogan "Drink Sportaid," more people are going to buy your sports drink. The only problem is you didn't get LeBron James' approval to use his picture underneath your company's slogan, right? So that would be an example of an appropriation by the defendant, that would be you, a plaintiff's name, LeBron's, or picture for defendant's commercial advantage. And LeBron may be thinking about bringing an invasion of privacy action against you, right, under the first branch. The second branch of invasion of privacy would be intrusion by defendant into plaintiff's privacy. And for this, the defendant must get into the plaintiff's own private corner of the world. So this would be the type of invasion of privacy if, for example, an owner of a retail store put hidden cameras in a dressing room. This is the branch of invasion of privacy that we'd be talking about. We have the defendant getting into the plaintiff's own private corner of their world. The third branch of invasion of privacy would be publication of facts placing the plaintiff in a false light. So a situation for this would be something like, let's say, for example, you got your picture in the paper, and the reason that your picture was in the paper was because you rescued somebody from drowning in a lake. And so the newspaper is going to put your picture in the paper. Now let's also assume there's an employee of the paper who doesn't like you very much. So the headline for that day was a local murder suspect which is caught. So here's the headline, front page of the local paper, local murder suspect just apprehended, and then underneath that is going to be your picture on the front page of the newspaper, and then maybe on page 8 there's a little story about how you rescued somebody from drowning. Now if you're going to start to think about bringing in action against the employee of the newspaper who doesn't like you very much, you might be thinking about a publication placing plaintiff in a false light. So if people were to read the story in more detail, they would basically find out that the murder suspect was not you, but anybody who is just looking at the front page of the paper now is thinking that you're the murder suspect. Finally, the fourth branch of invasion of privacy is a publication of a true fact that's private, publication of a true fact that should be private. So let's say, for example, that I needed to miss work for a few weeks to deal with a medical problem. I then came back to work at Edinburgh, and let's assume that Edinburgh has a newsletter that it sends out. And the newsletter states upon my return, "Welcome back, Dr. Engdahl. We are pleased to see that you're back to work after your bout with gonorrhea." Now let's also assume for a second that I did have a bout with gonorrhea, and that's why I missed several weeks of work. Well, that was a true fact, but it's something that I would want to keep private. So if I'm going to think about bringing an invasion of privacy action against the university or the publisher of the newsletter, then I would be thinking about this fourth branch, the publication of a true fact that should be private. Let's take a look at the fifth and final question in question batch 6. Question states, Ron told his wife Julie that Frank is a drug addict. Frank has never taken drugs in his life. If Frank sues Ron for defamation, based on the comments Ron made to Julie, a court would likely, I'll read that again. Ron tells his wife Julie Frank's a drug addict. Frank's not a drug addict. He's never taken drugs in his life. If Frank sues Ron for defamation, the court would likely A, impose defamation liability on Ron because he committed libel, B, impose defamation liability on Ron because he committed slander, C, not impose defamation liability upon Ron because Ron's comments to Julie were true, or D, not impose defamation liability on Ron because Ron's comments to Julie were privileged. Answer is going to be D, not impose defamation liability upon Ron because Ron's comments to Julie were privileged. That would be the answer. Now in this situation, Ron did make a defamatory statement against Frank, right? That would be damaging to Frank's reputation. We do have a publication. In other words, there was a communication to a third person, which was Ron's wife, Julie. And in this situation, we do have slander, that's the spoken word. But Ron's comments to Julie were privileged. This is an absolute privilege. This gives one the right to make a defamatory statement about somebody else, so long as they make the defamatory statement about that person solely to their wife or their husband. Okay, that would be referred to as an absolute privilege, communication between spouses. Again, answer is D. A court would likely not impose defamation liability on Ron because Ron's comments to Julie were privileged. And this concludes the lecture for Assignment 6.